This is Michael Cowan, and welcome to Trial Lawyer Nation.
You need to show people the worst possible harm that negligence could have caused, because that's what the case is about.
What I'm asking you to do is to focus on what you can control, because that's where the power lies.
The Dalai Lama has a saying that in the face of anger, justice evaporates.
If you can't focus group it, you have to be very, very critical of your process.
The facts aren't good, you can't create a miracle.
We can agree to disagree and be zealous advocates for our clients.
Quit worrying about looking perfect. You're not going to. That'll come in time, but you can still be an effective litigator.
Welcome to the award-winning podcast Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowan.
Today on Trial Lawyer Nation, we have attorney Chris Madeksho. Chris just got a wonderful verdict now, even during this age of COVID, and he's agreed to come on and talk about it and talk about his practice and how he got that great verdict. So Chris, welcome to the show.
Good to be here, Michael. Thanks for having me.
Oh, I love having you. I'm so excited to talk to someone. I'm just getting some judges tell me that we might actually try some cases this year. So I am so wanting, aside from just a show, I'm so wanting to learn from, how y'all did it. And so hopefully I can do the same. So let's just start with a headline and then I'll kind of cut to some of the background. So what kind of verdict did you get and where'd you get it?
So we got a verdict to the tune of $13,966,000 in King County, Washington, which is Seattle. And it was in a case where my plaintiff has mesothelioma, still living, obviously terminal, as most people know. But because it was a terminal cancer case, the judicial committee got together and asked judges which cases should be the first up. And our judge, Judge Rule, spoke for us. And he had the opportunity to be one of the first cases. And I didn't really feel like we had a choice. We can go into more of the backstory, but
yeah,
that was the case. He chose us because it was a terminal cancer serious case.
Well, I'm glad you got the opportunity, and I'm glad that your client got the opportunity to, get some sort of justice. I mean, I certainly wouldn't trade slowly dying of mesothelioma for $13.966 million. But at least he got something, some opportunity to be heard, and maybe the money could bring him some comfort and joy in life while he's still here. Because I know a lot of times the manufacturers try to spread those things out until the client dies, hoping that it'd be worth less money. It's evil.
And that's another story, because that happened in this case.
Yeah. Well, before we get into the details, I want to just get a little bit about you. So tell us a little bit about you and your practice.
So I detoxed tort. I got in this all thanks to my dad. My dad was an asbestos insulator in the Golden Triangle area, the Gulf Coast area of Texas. And after he decided he didn't want to do asbestos insulating work for the rest of his life, he went to the University of Texas at Austin, got a degree, got a law degree at U of H, and he's one of the early guys doing asbestos work.
Wow.
And he got me started, and he passed away in 2016. But he had left a lot of goodwill, and to this day I benefit from the goodwill that my dad left me, as well as all of the experience that I gained under him. So I'm an attorney. I had to move out of Texas after tort reform. My sister, however, is my law partner, Angela Madeksho. She stayed behind in Houston to manage our still existing Texas practice, which is, it's had to change because of tort reform, but it's still there. And I manage our California office.
Well, California, when it's not, at least I don't know how it is now with the fires, it's generally a fairly pleasant place to live.
Yeah, the fires have made the air quality index go in the wrong direction.
Mm-hmm.
I love living here. I love the people. I love everything about it. Miss Texas, but I love it here.
It's amazing. I I worked for another lawyer from when I became a plaintiff's lawyer and moved back home to Brownsville, Texas in '97 until he left in February '99. I had to go off on my own. And we were local counsel for Barron and Budd on, I think, 10,000 asbestos cases that were Alabama cases, but somehow they could follow them in Texas because there was a Union Carbide factory at one point in Brownsville, Texas. And I remember thinking back then that no point in going to asbestos because this is 1999. These cases are going to be done in 5 years. I need to specialize in something else. And there's not. It's amazing.
They've been saying that since 1984 when Johns Manville went into bankruptcy. There's not much left, but because there has been such widespread failure to disclose asbestos content of certain products, especially those containing talc, we still see asbestos-related disease in large numbers to people who have no idea they're exposed.
Yeah, it's disgusting on one hand that people would expose people to such a well-known toxic substance, decades after we've known how bad it is. But it's important we keep looking out for those cases. So I guess you kind of, I guess your dad would teach you, because the asbestos world is kind of its own world, from what I learned, as far as it's hard to break into, learning who to sue, what the theories are, the medicine. It's such a well-developed tort in some ways, but then it's constantly evolving. So it's not something you just go take one asbestos case and get into it. But from the trial skills point, because just knowing the science is not enough to get a almost $14 million jury verdict. I mean, you need to know how to try a case. What have you done to develop yourself as a trial lawyer?
Well, developing myself as a trial lawyer involved developing myself personally. When I had my first child, my wife and we got together and decided that I was going to take about a 5 or 6 year break from trying cases.
Wow. And
just build the family. She knew, and I knew from seeing my dad and a lot of his friends, that the law is a jealous mistress, and a lot of families had been broken up because people dedicated themselves to the practice of law and not the practice of family law. So experiment and just build the family first. And after we had a strong, stable, loving family and a strong, stable, loving hold on our personal life, then act and do our trial work. And it has, for me, since getting back into the trial work a couple of years ago, it's worked wonders.
Wow. That's funny, because everyone else says I'm gonna keep working, and I'm gonna not, one day when I somehow hit the right case, then I can enjoy my life. Your way seems to make a lot more sense.
Yeah, because I want to continue to do this, throughout. I want to be. This is what I want to do forever, as long as I'm able to get on my feet. I want to do this.
So, have you, anything you've done to study, or anyone you've worked with to learn skills for trying cases?
So, after my dad died, I went to the Trial Lawyers College, and I did the 3.5 week. My wife will tell you it was a month long.
Yeah. It was when I went there.
Yeah.
It was 30 days.
But yeah, I went there and went back for a graduate program and met Eric Penn.
Uh-huh.
And Eric Penn, talking to him about how he obtained that incredible verdict in Texas.
It's inspiring, isn't it?
It inspired me, and it inspired me to go to learn with Sard Lamont.
That's funny. That's how I met Sard Lamont.
Is it too?
Yeah, Eric Penn told me he worked with her to get ready for his opening, and I was getting ready to try a case, and I wanted to get ready for an opening, and I've been working with Sard for a little over a year now. Small world.
Well, Sard Lamont's techniques, and I need to give credit to all these different helps, but Sard Lamont's techniques played directly into the techniques and the language that was used in this case. But and then Jesse Wilson also, his method of developing the story you tell the jury was very effective, because we had minimal damages presentation but obviously the verdict, 13.6 million of it is non-economics.
Oh, wow.
So only 366,000 is economics. So the damages story was obviously effective enough with this very conservative engineer and accountant and teacher heavy jury.
Wow.
So really those three, but I've also been reading a lot. Nick Rowley is inspiring.
Yep.
I read his books. Keith Mitnick, obviously. I read Rex Parris. Anytime Rex Parris talks about books to read, I go to Amazon and I buy those books.
Yep.
So, that's pretty much the background of the trial techniques that I use.
But it's a lot of work, it sounds like, to kind of get the tools you need to go try a case.
It's everyday work. Every day you work. Every day I'm up at 5:30 in the morning, doing work on myself, make sure that I'm comfortable and my body is in a situation where it's comfortable, so that I don't have, as Sard Lamont would say, body language contradicting my spoken language, which would be believed over my words. And to have a comfortable body situation is important. I think was helpful to us in this case.
Absolutely. So, tell me a little bit about the case then itself.
So yeah, it was a hard fought case. The man was a 68-year-old living mesothelioma victim at the time of trial, 67 at the time of diagnosis.
And for those that might not know, mesothelioma is a lung cancer, incurable, that is pretty much only caused by asbestos.
So this is the lung. If there's a saran wrap, you imagine saran wrap around this lung. That saran wrap is a cell-thick layer called the mesothelium. And if the asbestos is breathed in and through the nose and makes it all the way through the lungs and out to the mesothelium, and the cancer develops there, which the asbestos fibers preferentially clear to the pleura, you have what's called a mesothelioma. Very rare, very always fatal disease, super painful.
An awful way to die, too. It's like being slowly having water put in your lungs and drowning or something over time.
You drown to death in your own fluids. You're trying to stay alive. Cruel.
That's awful.
But his exposure was when he was a kid. And that played into the story that I got from, that we developed and we told in this case. He started working at 9, worked with a Kaiser gypsum joint compound product until he was about 19. His dad died of a heart attack, and then he went on and did something else. But there were some difficult facts in the case that made us have to drop the loss of consortium claim. And so the only damages that got in front of the jury were the actual personal injury damages to our plaintiff himself, and nothing about family life or the love story. We couldn't talk about that. We had to focus on him. So that's our plaintiff.
So what did you then do because over $13 million in person damages or non-economic damages is incredible. What did you do even for all the suffering you go through, and you're going to go through with mesothelioma, that's still a really incredible result. What did you do to develop and learn that story?
So as you know, having gone to the Trial Lawyers College, you have to understand your plaintiff very well if you want to present that. And so I did some psychodramatic work, making sure that I was comfortable in my client's skin, that I felt the love for my client. Paco Duarte, Bill Gilbert, those guys?
I don't know them. I'm a 1998 trial lawyer college grad, and I left. I stopped serving on faculty by my own choice in 2004. So I'm.
They're a little after you.
Yeah, I'm a dinosaur in that world.
Well, they led a group that helped me deal with issues that I had in this particular case with this particular plaintiff. And after that psychodramatic work, we had a psychodramatic encounter. You know what that is?
Yeah.
After that work, I was good to go. And it was just all about getting the getting the language right. And that's when I went to Sarah Lamott and using her techniques, and then going to Jesse Wilson, learn his storytelling techniques, and put on the case.
And just, I want to make sure I'm clear. So even after you learned the client's story, you had to do something to overcome your own internal bullshit. I don't know what the right word is. That you had your own internal issues you had to get past to be able to tell the client's story.
Yes.
To the extent you feel comfortable, can you explain that a little bit more?
Yeah, there was a criminal history in this case, which was the reason why we had to drop our loss of consortium claim.
Okay.
So we could not present on any. The judge had made a ruling that the criminal history wouldn't come in if we did not present damages evidence to the effect that our man was an ideal family man, etc. And I had to deal with my own feelings about the history.
Yeah.
Because we were doing this work, we're doing a mock voir dire, and Bill Gilbert sniffed it out. He's like, "You have an issue with your client." And I was like, "Yeah, I do." And so he's like, "Okay, stop." And when you're doing that, when you're workshopping a case and a psychodramatic need arises, you immediately stop and do that work. So that's when I did that psychodramatic work. I think that's probably it. Does that answer your question?
It does. It really hit home with me because I'm getting ready to try some brain injury cases. And one of the problems with dealing with clients who suffered a brain injury is they're not rational. They're hard to deal with. They don't make good decisions. And in the course of representing somebody and dealing with somebody with a brain injury, when they have a real brain injury for a couple of years, is you get frustrated with them.
Yeah.
And you need, one of the things I'm realizing is I got to work through that on my end, because if I am frustrated with my client at the time of trial, no matter how much I have in my head that this is from the injury, if I don't work out my issues with that, it's going to come through in my body language. It's going to come through in my tone. It's going to be a discongruent story. So I'm realizing that when either something the client's story hits home personally for some reason, or if we get frustrated with them and we need to do the work to really get past that, or we can't fully tell their stories.
Right. Or you can't tell it the way you need to.
Okay, so it's COVID. How did you said you had a judge that went and fought for you about being able to get to trial. What did the defense do? Did they want to try the case?
So no, they did not. As you observed at the outset, they did not want to try the case. Obviously, it's advantageous for them, for the client to die, and then you don't have the same story or the same damages present. So we waived jury to get a bench trial before he died. And they opposed our waiver of jury, saying that, yeah, unheard of. Mesothelioma case. So they wanted the jury trial. So then the judge said, "Okay, well, I'm going to still push this case." And he gave us some rulings saying that you better do this, this, and this if you want to get this case ready to try. My co-counsel, Weinstein Cajano up in Seattle, they worked with me, and it was just a blessing to have them on my side. We complied with the judge's order, and by the time the trial date came, we were ready to go.
So what did the judge do then to assure, the juror's safety, y'all's safety, everything else when you're trying this case?
So the first couple of things that he did, the jury summonses went out via email. The responses were fielded via email. All of the hardship questions were concerning COVID and everything else were handled before the panelists were examined, before voir dire. And in handling all of the COVID-related hardship issues, we pretty much took care of all of that. And I think that you've probably been on the same plaintiff's attorney email chains I have. We knew that the jurors who are not afraid of COVID are our most dangerous jurors, And the jurors who are there, even though they don't want to be, are our second most dangerous jurors. So when we got the responses to the questionnaires back, and we knew who the COVID hardships were, the judge, in order to safeguard the safety of the panelists, the judge said, well, y'all have any issues of letting this go? And I was looking at the list, and I was immediately half the panel. And at that moment, I said, no. Let him, Your Honor, no. Defense counsels, they also agreed, no objection. So immediately, the judge, taking care of the safety of the panelists, allowed us to also take care of our biggest concerns. So then I was already a head start.
Were you worried because the jury summons were by email that you weren't going to have because it sounds like you got a conservative jury pool. Now I know you're in Seattle anyway, but there are people out there that don't have email that might be good jurors or don't have ready access to computers. That it was going to change the demographics of your potential jury pool.
Yeah, and it did, because the response wasn't great. The response to emails wasn't great. You didn't get everybody that you would typically see in a King County jury. Instead, you got people who had means, and you had people who were always on the computer and engaged with technology. And anybody who's done any jury research knows those are people who are probably a little more conservative.
Yeah.
So yeah, that did play. But when you have a client who's going to die if you don't try this case now, I mean, you just kind of do the best you can.
Yeah. And that's what I've realized. As we're sitting here without a clear end date, that we may just have to try cases the best we can with the best panel we can get.
Each year, the law firm of Cowan Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach Delisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowan to speak with you in person or by phone to discuss the case in detail. And now, back to the show.
So how did y'all do the jury selection? Was it in person, by Zoom? How was that done? Both.
And that's to how we did it and the techniques we used. So there were a total of 6 panels. 4 Zoom panels of 8, 1 Zoom panel of 6, and 2 live who were live because they had issues concerning Zoom and security.
Okay.
Personal issues, which I understand. I mean, that's reasonable these days. So we had 2 shows live, and you could tell the difference. Having done 6 panels over the course of 2 days, you could really tell the difference that it made.
How was that?
So when you're looking like you and I talking right now, I mean, it's wonderful. We're simpatico, we're on the same side, and we're trying to help. But when you don't know anyone or anything about that person other than what's been on a piece of paper, you don't have that same connection.
Right.
So not being able to be present and observe that person and have that person observe you, it's difficult because we as trial lawyers work so much on our nonverbal gesturing and physical presence that for us it's an incredible advantage if we've done the work over defense counsel who's never gone to trial lawyers college, who's never gone to Sard Lamont, who's never worked with Jesse Wilson,
Yeah.
So I felt that I connected much more strongly with the live panelists.
And the jury you got, how many of them came off the Zoom panels and how many came off the live?
14 came off Zoom and 1 came off live.
Okay, so even though you had a bigger connection, that wasn't a lot of the people. How many people actually got to vote on the jury out of that 15?
Out of the 15, only 12 voted.
Okay, different states do it different ways. That's why I was asking. So when you were doing the in-person jury, and one of the reasons I'm asking so many detailed questions is I promised a judge at a hearing yesterday that I was going to take I interviewed another lawyer out of Pennsylvania, Brandon Lupiton, who recently tried a case there, and then I'm interviewing you today. And I promised my judge I was going to get him transcripts to show how to try a case safely if he'll let me get to trial in October. So what safety measures did you all take to protect everybody when you're doing the in-person voir dire?
So talking about safety measures, I need to email you a picture of the spacer they used.
Please.
They put chairs next to each other, separated by a wooden spacer. There was 6 foot, that had notches that were 6 foot in length that would fit on top of the particular chairs that they use at the Maidenbauer Convention Center in Bellevue. And so they spaced the chairs. Everybody in the courtroom was masked. Everybody never saw me without a mask on my face, not 1 second. Throughout, from voir dire all the way to closing argument. So we were spaced, we were masked, and during break, we attended to our lunch and counseling needs on a different floor. So those are the main safeguards given to the jury.
And the actual jury selection, then it sounds like you didn't do it in the courtroom, you did like at a convention center, so you'd have more space?
Correct.
And when you actually were trying the case then, where were the jurors seated?
So if you imagine a conference hall that has a 20-foot high roof, that is probably 60 by 80 feet. One half was dedicated to the court staff on the side, the judge on a day in the back at the 2 large screens, one behind the judge and one behind the court staff. The center, the galley, or the well was open and that was accessible to a stand, and it had like a computer with an Elmo on it that you could project onto the screen. And then on either side of the well was the defendant and the plaintiff. So that was the setup. And then on the other half, where the jury was, every juror was 6 feet from one another in every direction.
And you said you have a picture you can send us so we can put it on the show notes?
I have a picture of the spacer. Inside, I don't know that I have. I don't know that
that's okay. Yes, anything. I think we're all. I don't know about everyone. I mean, the judge yesterday said I was in the minority, but there's some of us that are dying to try a case again, but we don't want to literally die to do it, or result in any juror dying to do it. So we want to figure out, how can we? The more we can learn about how to safely do this, and it sounds like you all safely did it.
Michael, if you. I've made myself available to some friends in the Midwest. If it's helpful for me to Q&A with anyone, just let me know.
Okay.
We need to get the wheels of justice turning again.
We absolutely do. All of our biggest, our regular, what I call our regular cases are still settling, but all our big monster cases, until you have that real trial, until you get in the courthouse, they don't get serious.
So if I can help, just tell me when and where.
Chris, I really appreciate that. So let's talk about, so you picked your jury. Now, were you stuck at the, kind of at the lectern when you're speaking to the jury, when you're like doing opening, or were you able to walk around some?
And lectern was the word I was searching for. No, you know how we are. I mean, trial lawyer TLC says no lectern. And so I did not use a lectern. When I examined a witness, now opening an argument is very different, right? But when I was examining a witness, I was seated in a chair. I had my computer up, and I was looking at the screen, the Zoom screen, and all the witnesses appeared. One appeared live, and every other one appeared via Zoom.
Okay.
I was sharing the screen to examine the witness with a document, and then that would be cast up on these large screens that I mentioned that were behind the judge and behind the court staff. So all of that was seated. All of my witness presentation was seated.
I was going to ask if you could approach the witness, but I guess if they're by Zoom, you couldn't anyway.
And I know you could not, but the jury, as you could probably imagine, likes to see some activity.
Yeah.
So what I did was, when I wanted to introduce an exhibit, I would stand up,
Yeah.
and very similar a copy to the court staff, a copy of the exhibit. I'd walk across and I would stand in front of the defense counsel, and I would hand a copy to the defense counsel. When they said objection or no objection, I would then ask permission to approach, and I'd give it to the judge, and I'd come sit back down. Maybe unnecessary, but absolutely recommended if you want to keep the jury awake.
Yeah, I think you need something to just change it up and not just be watching the screen all day. So did you have your back to the jury when you're questioning witnesses, or your front, or how were they kind of situated?
No, they were to my right, and the judge was to my left.
Oh, great. And was it an actual courtroom, or did they rent a hall or something?
The county of King has rented the Maidenbauer Center for some monthly sum, and the Maidenbauer Center now is no longer inactive, but they have income, and they provide their IT staff and their coffee cart staff and their security staff, and make them available to accommodate all the court needs.
Okay, so it's like a big conference center instead of like where we'd have a CLE or some of that type of room.
Yeah, it's like the equivalent of a continual CLE.
Yeah, great. Yeah, because I was wondering, some of the courtrooms that we practice in have been really small. I guess we'd have to encourage the judges to find some other spaces to do them in. So let's talk about your opening then. You said you worked with Sari on language.
So, in some of the voir dire, I was able to do the Sari de la Motte technique, and some of it I was not. I had to save the panel because we were about to bust it, so I had to do straight, TLC tribe building.
Yeah.
But at the outset, the very first couple panels, I used Sari de la Motte's technique of getting the language from them that I would be then employing in the case by asking them a question that I had crafted with some hostage to hero members in a voir dire circle. And the question was, so you have it up. Okay. The question is, what should a company do to make sure it sells a safe product to the public? That's the specific, very, very succinct question that I asked. They gave me the answers back. I take those answers and I put it in my opening. And then I take to create the ringing the bell,
Yeah.
And then I take those answers and I put it in my closing to give it back to the people that I thought were going to be the thought leaders on the jury. And it worked.
So you actually went and incorporated some of the what the jurors answer, how they answer that question into your closing.
I not only I reached for it, because one of the juror who was we thought was the likely foreperson and who was the foreperson on this jury gave me something that fell outside the quote unquote ringing of the bell.
Uh-huh.
And I found a way to incorporate that language into my closing. When I did it, his head, you could see his head shot back like this.
Can you give us more detail? Tell us what it was.
We had strict products liability and negligence. Those are our two causes of action. And negligence, strict products liability, you don't need it, but in negligence, what would a reasonable company do under the circumstances? And here's what I did. I used a little bit of the NLP and a little bit of the, and I said, well, what does a reasonable company do? And I just kind of sat there and I looked at everybody on the jury. What does it do? I asked it again. And then I looked at him and I said, well, we know what a reasonable company do because we've seen them do it. They would recall. They would warn. And when I said recall, that's all he needed to hear.
Yeah.
And so that's how I did it.
Awesome. You mentioned the term ringing the bell, and I've worked with Sari, so I have some idea what that means. I don't know that everyone listening does. Can you tell us what it means when you're talking about using the technique of ringing the bell?
That's your liability mantra. Ringing the bell is the three facts in your case that prove that your defendant is liable and responsible. And for this particular case, they didn't warn, they didn't test, and they didn't provide safe instructions. That's my ringing the bell. That's an example of 3 things that showed that my company was, that my defendant was liable and they were responsible. They needed to be held accountable.
And you make sure you repeat that over and over again throughout the trial?
I didn't have the opportunity because of the way that we presented a lot of the witnesses, but with one of their expert witnesses, they didn't call a corporate rep. This is the reason I say that. They ended up not calling their corporate rep. But I ended up using it with one of their expert witnesses. I used it in opening, obviously, and I used it to close.
Yeah, that still works. I mean, as long as you do it, obviously it worked. I mean, you got a bigger burden than I've ever gotten. I'm not going to tell you how to try a case. So tell me about talking to jury with a mask on. That's one of the things my partner and I are doing a work day on our trial tomorrow that we have to set in November. And then I'm going to work some with Sari on it. But one of the things I'm really, I guess, having trepidations about is how do I talk to a jury with a mask on? What was that like? All these different psychologists, psychoanalysts, jury consultants, trial theorists, all of them, there's an underlying common current. And basically it's, you got to be at ease, and you have to be at ease with yourself internally, such to where you can be loving and kind to this jury. And because it all comes out to the eyes. Yeah, I was going to say, because they don't get to see the rest of your face. That's right. The eyes are, it's like this. If we are in a room and we see everything nice and bright, we don't really have to pay attention a whole lot. But if I turn these lights off, and all we got is just a shimmer of light reflecting from another room, I'm going to pay real close attention to those things that I can see. And when you don't have, we're attracted to looking at other people's faces. And if all of a sudden your face is all covered except for the eyes, then you are exactly the same position. Your jury is in exactly the same position as you would be if you're in a room with very little light. You're looking at the things that you need to look at in order to be able to safely navigate. And if they want to know who to believe, they're going to be looking at your eyes. So, yeah. Did you do anything to try to gesture more or anything, or you're just going to be comfortable in whatever happens naturally? I gestured less. Really? Yes. You have to appear. For me, there are a lot of people who are going to be listening to this who try a lot more cases than me. But for me, I find that I'm most effective when I'm calm, and when I'm just open and considering that other human being that I'm interacting with. Uh-huh. And to be calm, I have to be at ease. So my body isn't very active. Okay. And look, you have to be you. So, what like Sari says, the worst thing you ever see is a lawyer trying to imitate a Jerry Spence closing, for example. You got to be yourself. And so, no, I was just curious about that, because that's one thing I've been like, do I have to gesticulate more because they can't see my face? It's just something I've been thinking about. So tell me about how you structured your opening. I structured my opening by focusing probably about 90% of it on the conduct of the defendant, 5% on damages, and then the rest of the 5% of it was just, this is an important time in this country. I didn't move away from the elephant in the room. What you're doing here is a big deal, as the judge has said repeatedly, and this judge had said repeatedly at one point, even getting a little emotional, as I did during the only live panel. I got a little emotional, something that I try not to do in voir dire. But that was my opening. I just focused on the acts of the defendant and getting across to them that this is a story about all of us. What do you mean it's a story about all of us? That's brilliant. I really want to hear a little bit more about that. This particular, I think we should all try to do this in all of our cases, but this particular case was tailor-made for that type of theme, because one of the liability exhibits
was a map of the United States with the centers of manufacturing and distribution for this company. And looking at that map of the United States, you could see it all the way up and down the eastern, southern, and western borders of this country. And you better believe that was one of the things I keyed in on an opening. You better believe that was one of the things I spent a lot of time on in crossing their PMK, which luckily I videotaped it, which we're going to have to start videotaping now, all of our witnesses in this COVID era. But I videotaped it, and so we put that up on the screen with her. And then at the end, when it came time to discuss the strict products liability and about the likelihood of damage, that slide is the slide that I put up again. So it was a story of them and how they treated people in this country. Workers. I hit on the fact that they were also selling this product to home remodelers and DIYers.
Oh, wow.
So it was a story of all of us.
Really, as the reptile people say, really spread the tentacles of danger there. That's a good job. So how did you tell the story of what the defendant did wrong? When you're doing your past opening, you're presenting your evidence. What do you do to tell that part of your story?
Well, you need a villain, and you need it to be concretized, and that villain usually needs to be a human being. We had a memo that was the earliest memo we could find imputing actual knowledge, and the page of that memo had a bunch of names on it. So I blew it up, highlighted the name, and I put just that section with the names on it up there. And then the very next slide was the picture of the United States. So they were my villain.
Yeah, that's interesting because I've actually, David Ball and I have had some really good discussions on this. I've been doing a lot of thought work into what makes a villain. And so what I've been looking at is theater, screenplay, movie, TV, what is it when they're teaching the people how to write these things? What are the characteristics of a villain? And it's typically dishonesty, greed, intelligence, power, but they all the screenplays say it's an individual. But yet I've been told all the time, make it about the company, don't make it about, the low level people. And, is it, does it need to be an individual high up person at the company, or can it just be kind of some amorphous corporation? And, David Ball, who I respect incredibly, says, well, corporation can be a villain. It's like this nameless, and I'm not so sure. I think that the way people think, you can't imagine a corporation doing something or not doing something. But if you can think of the executive who made that act or omission, it makes a huge difference. Now, you want to go as high up to find someone who's smart, someone who's powerful, someone who's doing it. This is ideal. You don't find in every case for a bad reason, and then someone who's deceptive. The defendant's trying to cover up or trying to hide their conduct. I think you get all that together, you get your perfect villain. Yeah,
I agree with you. David Ball may be right, but he's not right for me because I can't integrate that. My mind it just doesn't agree with that idea. It agrees more with your idea that a villain has to be human. So that's the only one that I can effectively communicate for that reason.
I have a book chapter on the book I'm writing, and that's part of, casting the villain is one of the chapters, and I keep putting it in. I haven't submitted it yet because I keep having that fifth element of being an individual. I keep putting it back in and taking it back out, and I've been doing that for about a year now. I've been working on other things during that year, but I mean, it's just I just can't. It's just so hard to do to figure. I mean, on one hand, I don't want to disagree with David, but then, it's so hard to find that individual. It's a good thing you had that memo at your on your case.
Yeah, we had a memo and we had a picture of him.
Oh, so you had people. That's even better.
You had a picture of him. I decided not to use it in favor of the current corporate representative. He was the corporate representative, the guy who designed the joint compound with asbestos in it.
Okay.
I used their current corporate representative because I was able to interact with her.
Yeah.
And I thought that the jury would find her more tangibly relatable and more willing to cast her out.
Yeah, because that's aren't you often like the true villains were back in the 50s and 60s sometimes, right?
Yeah.
And so it is nice to have someone that you can actually question, not someone that's long dead.
Yeah.
Because that's the other problem with a villain. The villain's long dead. Then what difference what does the jury need to do? You need to have some ongoing reason for them to do something.
That sounds, yeah, okay. Yeah, I was about to say that very same thing.
What was your reason then? I mean, if this is a product that's not made anymore, I mean, it's still out there. People are still getting sick, but that's already been done. In your head, what's the reason the jury should give a crap?
So there's a kind of a sub story to this.
Okay.
And it came through when I was doing the tribe building portion of the voir dire, and then trial argument is that during this time, there needs to be law. There needs to be the justice system. And we need people who are going to follow the law. And the law says this, otherwise, what do we have? And it came through more in my voir dire in closing than in my opening. But that was certainly the way that we approached having a conservative jury consisting of accountants and engineers and teachers.
Well, that's something that definitely resonates with the conservative jury, too. I mean, we've got a presidential candidate that just tweets law and order in all caps, and there are people that are celebrating that. I'm not going to get political in this podcast. But the fact is that we have laws and people need to follow them. If you have a more conservative jury, if you can make that your theme, I think that's a good one to have.
Yeah, and the way that we did it in voir dire is those people that were more conservative I said, here we have a corporation and you have a person. And the law, you heard the judge say in the pre-instruction to you that you need to treat them equally. Are you going to be able to do that? I mean, no sympathy to the plaintiff, sure, but also no sympathy to the corporation. Are you able to do that? And I got a commitment out of every one of the jurors in the last three panels.
Awesome.
The first few I wasn't able to do that. Then we started losing a lot. In the last three, I had to keep more, so I kind of changed.
Yeah, it's interesting how you get in there. You talk about the consultants will tell you about the ideal juror, and I remember I got to watch Lisa Blue pick a couple juries on asbestos cases, and they'd have to bring in this massive panel because she could strike so many people. And and I've been in there sometimes. I can go strike a bunch more people, but then the judge is going to tell me to come back in 6 months. And now most of my cases, my client's not isn't dying, but there's still a chance of death, another injury. My client does something stupid and gets arrested. All kinds of horrible things that can happen if you wait 6 more months. And sometimes you got to get the best panel you can get that day.
We were having to get the best panel we could get because our guy wasn't going to live. I mean, I hate to say this on camera, or he's not going to be around long. So if we had busted that panel, we probably would not have gotten another trial date in 2020.
Yeah.
Then what? So we just had to keep them all, and we had to adjust our game plan, and we couldn't focus on that ideal juror that we had in mind before we started. That's exactly right.
And I think that's doing what's best for the client. I mean, it is. I think there is a value to him, whether he gets to collect it, whether he gets to enjoy it. There is a value to being heard and validated before he dies.
I can tell you that for this particular man, he needed to be heard and validated more than anything else, simply because of the issue that we faced, the life that he had led, his redemption story, the last 30 years of trying to be the best human being that he could possibly be. He needed that as much or more than anything else personally.
Yeah.
Giving that to him is one of the highlights of my career.
Yeah, I realized that in the last case I tried is that, the case had kind of been around for a long time. Other lawyers had handled it. We finally got brought in to try it. And she's like, and she was so hard to get to open up. And we, took a lot of work to get her to open up. And she finally said, you're the first people that listened to me. And before this case had been bumped so many times, she goes, I didn't think anyone cared that he died. I didn't think anyone cared about me. And going through trial was difficult for her, but it was such a cathartic experience that I think it's going to make some major changes in her life, positive, because she was, whether we ever collected or not, whether we keep it on appeal or not, the fact that people cared enough to listen, and that she was heard, and that someone said what happened to her and her late husband was wrong. I mean, there's just an incredible value to that above and beyond the money. The money's important too, but above and beyond that, I think that is so good that you were able to do that for him while he's still alive, and hopefully he can live as long. I mean, it's unpredictable,
It is unpredictable, I mean, but what you say, trial law can be a healing art.
It really can.
We can heal human beings. We can heal communities. It's an incredible. I mean, this American system is a bit of a modern miracle.
Yeah. So, what did you do then to tell the damages story at trial?
So, to tell the damages story, we had taken the video deposition, preserving trial testimony by video deposition of, I think, 5 witnesses. And by the time we got to trial, we really looked closely at the story that we could tell and that we wanted to tell, narrowed it down to 3, cut it down to 10 minutes, and made it all about a man who had worked his entire childhood, and now that he is in his final days and is enjoying his relationship with his grandchildren, is living his childhood for the first time.
And that's taken away because now, I guess, would you use the doctors then to talk about the suffering, the stuff he's going to go through and he's going through, or how did you get, or did you?
Yeah, we actually used even the defense for that.
Even the what? I couldn't hear. You broke up there. The defense doctors. That's brilliant. Tell me about that. How did you do that?
So they brought a pulmonologist who we discovered had a history of treating mesothelioma. And he had treated them, obviously, decades ago. But there's no denying that this is an extremely painful disease to live with and an extremely painful disease to die from. So in as broad and bright line examples as we could, we asked him 3 or 4 simple questions, and then we blew them up in the slides for closing.
Right. I think it is so much more powerful when we can get good stuff. I mean, what was he there to talk about? Why were they bringing him?
They were bringing him to defend on causation.
Okay, so they were saying that this cancer was not caused by either asbestos or our asbestos, or what?
Correct.
And so, but then you brilliantly said, well, yeah, I might fight that, but let me see what I can get out of them to help me.
Yes, and in fact, it was I can't take credit for this one because it was my co-counsel, Alex Cajano. She did an incredible job with this man, and this is actually a teaching point. Aside from getting damages from him, because his history allowed that, we did it. But in the era of Zoom trials, she did something that I'd never seen before. She examined him because he was on a screen and she knew his history, and he had given a bunch of depositions before. In the space of about 45 minutes, she examined him about 60 or 70 medical articles. And by the time she was done, he was just stunned. It was just too much information for him to comprehend because he had been examined on these articles. But she just took the best parts out of all of it. And by the time it was done, he didn't know where he was.
That's awesome.
It's something that we can do with this type of trial.
So she just got the article and just highlighted the best parts and just put it up there with him?
Right. Alex Cajano, she did that. It was amazing.
Thank you to everyone who attended Cowan's Big Rig Boot Camp in August. We had an excellent virtual turnout this year and are already thinking of how we can continue to raise that bar for next year. If you'd like to attend virtually in 2021, be sure to mark May 20th, 2021 on your calendar now and save the date. To stay updated with details as they become available, visit bigrigbootcamp.com and sign up for our mailing list. And now, back to the show.
So what else, I mean, was special about this trial? I mean, you got such an incredible result. What else can you tell us that could be helpful to us when we're trying our cases?
So you have to, because we're going to be tethered to a computer screen, you have to get on your feet when you can. And that means if you're opening, if you're closing, if you are, tendering an exhibit to defense counsel, just do so with grace, ease, and love. And when you're on your feet, setting this scene in an opening or a closing, really, really work at that. Do it dozens of times. Make sure that by the time you've finished being up on your feet in front of the jury is there with you in that space. And if you do that, then I think that you will have overcome some of the larger obstacles that face us in this kind of a sequestered trial environment.
We're all trying to get better, and you just had this result that we all aspire to be where you are right now. What advice do you have for those of us that want to get better, that want to get to that level where we're getting those kind of verdicts?
Right. If you're listening to this, then chances are you're somebody who's picked up a book. You're somebody who is tuned into a podcast. You're somebody who has read an article, and you know a little bit about trial advocacy. What you need to do next, after learning a little bit about trial advocacy, is you need to get in the courtroom. And this time in America, the COVID era, it presents opportunities, even though we're not trying cases right now. What I did before COVID to really become comfortable in the courtroom was I went and contacted an eviction defense organization called EDN, Eviction Defense Network. And a woman there named Elena Pop was overworked. She had many more cases to try than she could try. And so she just brought me in and said, here, try as many cases as you can. And that's what I did.
Wow.
And so I got in the courtroom and I tried pro bono cases for low income, non-English speaking clients. And that made all the difference in the world for me and for anybody else who wants to really be the best trial lawyer they can be. That opportunity, I'm willing to say it's there for you. It's there for your community. You can develop not just your skills in the courtroom, but the love that you need to have for this justice system that we have and for the jurors that are going to be fighting for you when you give your closing argument and they go into another room.
That's awesome. Yeah, there are so many opportunities. There's, eviction defense. There's credit card defense when someone's being sued by a debt buyer, and if you actually go to defend someone, they can't prove what the actual credit card agreement was that the client agreed to. They can't prove what charges were made, who made them. They're trying to use someone else's business records, three transactions removed. You can really help some people. Of course, little car wrecks, consumer disputes. There's lots of opportunities if you really want to get in there and help some people and sharpen your skills. There's lots of opportunities to do it out there.
Yeah, just whatever works for you. If it's credit card or if it's a small car wreck case, I mean, you helping somebody for free, it will. You may think that it's taking time away from you and money away from you, but the benefits that you get from internalizing having done something that worthy and that good for this society and this world, you'll see the benefits. You will.
One thing we're hearing a lot from defense lawyers and insurance adjusters is, people are suffering so much with COVID right now, and there's over 200,000 deaths that people just aren't, jurors just are, they're hardened. They're not going to care about our clients. They're not going to give much money. What is your thought on that, having now tried a case in the COVID era?
That was used in defense's closing argument.
Really?
Really. And he knew every single word that you just said, he knew because he pretty much recited that verbatim to the jury in his closing argument.
Wow.
And, he even went so far as to say there's a lot of people who are going to be dying painful deaths in this COVID era. They're not getting any money. When he said that, the jury set their tablets down. Nobody wrote. the remainder of his argument.
Wow.
So, and I can send you these transcripts. I mean, you'll see his words. And I think that if we stay stuck on that, then we have violated we have violated a rule we learned very early on. And that is, if you want them to trust you, you have to trust them. And if you think that they're going to be swayed by these cynical and gross arguments, well, then all that means is there's something in you that needs work.
Yeah.
And if you are able to stand up and put on your case and believe it, then by the time they stand up, if they have the balls to say a lot of people are going to get sick and die, therefore award no money, then what they have done is they have just ostracized themselves, and they have chosen to take a leaf from the tribe.
Well, that body language, I mean, the putting down, stopping the notes, it just absolutely nailed it. That's good to hear. That's really good to hear.
We gotta believe in our juries. You know, it's hard to do, but
I agree. I think that the biggest shift for me in winning cases since I've been working with Starry is my mindset of these are good people that are here to do the right thing and trust, and I need to trust them. And that change from being afraid they're going to screw me over to thinking of them as good people who are going to help me, or actually help my client, and they want to do the right thing, and that I can trust them to see through bullshit because they're smart enough to do it. It's just been a night and day change, and my results are so much better since I've had that mindset. And it's more fun and more comfortable to try the case too.
It is more fun, and you get it, and you feel like you're cloaked in this, this aura of goodness when you stand up and you're with the people that you trust. That alone has to have some sort of body language change that fits us, I think.
Absolutely. So you said you might be able to send us transcripts or something we could put in the show notes if people want to read the stuff?
Absolutely.
Yeah, that would be awesome. So we can do that. If someone wants to get a hold of you and they have more questions, or maybe they have a case they want to work on with you, what's the best way to find you?
So, my email is cmadeksho@madeksholaw.com.
Okay.
Or you can just go to madeksholaw.com and shoot an email to that.
And do you mind, since a lot of people are just listening and not looking at the show notes right now, you mind spelling Madeksho?
Yeah, it's M-A-D like David, E-K, S like Sam, H-O. Okay. So that's cmadeksho@madeksholaw.com. And I mean, yeah.
Well, great. Well, I so appreciate you taking the time to come and share with us, how you tried a case during these interesting times, and how you got an incredible victory. I hope you have many more, and I hope to be able to follow your footsteps and try some cases soon. So thank you so much.
Thank you, Michael.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowan Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach DeLacy Friday by calling 210-941-5600 1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowan to speak with you in person or by phone to discuss the case in detail. This podcast has been hosted by Michael Cowan and is not intended to, nor does it create the attorney-client privilege between our host, guest, or contributors and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.